morning, and welcome to Talk of the Town on 99.7, 1450 WHTC, and WHTC.com.
And we welcome you to Talk of the Town for this Friday, June the 12th. I'm Gary Stevens. We'll be open line after the 10 and 11 o'clock news blocks, and we'll be joined in less than an hour by Patty Vandenberg with What's New Around Holland, and Allegan County Board Commissioner, Board Chairman Jim Story, and possibly Commissioner Dean Kaplan will be joining us in about an hour from now with the monthly update from Dumont Lake, where the Allegan County administrative offices are. But on the second Friday of the month, our first segment is Ask the Attorney, your opportunity to talk to a local attorney. Probate is for the most part, but other aspects of law, criminal law perhaps, but more civil law, legal law, business law are the topics that can be answered sometimes by Nathan Box of Central Park Law. But today and every even-numbered month of the year, which means it's the 6th month, that means Ken Puzycki of the Law Office of Kenneth A. Puzycki is on the other side of our Zoom connection from his offices in Holland, and he joins us now. Ken, good morning, and welcome back to Talk of the Town.
Hey, Gary, good to see you.
Looking good, and if you have a question for Ken, no, don't try to connect to our Zoom connection. It's just between me and him. But you can talk to us the old-fashioned way over the phone at 395-1450, 395-1450. As I mentioned, probate is the thrust of a lot of our conversation, and there's a lot of questions about that. But we're also going to talk about some business aspects, especially as we are emerging from restrictions over stay home, stay safe, and safer at home. Businesses are starting to slowly get back their operations. And that, of course, means that they're going to have some restrictions or some new I don't want to call it new guidelines, Ken, but they have to handle their business a little bit differently, as well as on the legal aspect as well.
Yeah, in fact, my office manager has spent the better part of the last month putting together our own internal regulations, if you will, for social distancing and what we need to do internally while we are here, but more importantly, how we need to conduct ourselves when the clients come in. We don't have many clients coming in, certainly not as many as we used to. We're doing a lot of our consultations via Zoom. But we've got a laundry list of do's and don'ts when it comes to having clients stop by, because we don't want to infect them if in fact we have the virus, and we certainly don't want them to infect us or any of the other clients that might happen to saunter into the office when they're here. So yeah, times are changing. A lot of the requirements though are just common sense. You know, the mentality should be assume you've got the virus. Don't spread it to others. How do you not spread it to others? Wear a mask, keep 6 feet away, don't get too close to people. If you're going to cough, obviously cough into a handkerchief or your elbow. But other than that, things are getting fairly back to normal.
Now, Ken, you talk about some of these measures that need to be done by businesses on a health basis, and that's fine and dandy, and that's great. But it's also a case of maybe preventing a business from being part of litigation if somebody contracts the disease, and they might take the business to court.
Yeah, my knee-jerk response to that is good luck proving it. If you come down with COVID-19, how do you prove where you got it? Now, if I'm the only place you went to outside of your home, I suppose you might have a chance. But other than that, if you're going to the mailbox, you're grabbing mail that was delivered by a mail carrier who wasn't wearing gloves. How do we know you didn't catch the virus that way rather than by coming into my office or a car handle or a door handle? And like I said, my office manager, she's been, putting together a list of things that we do. And one of the things we do is wash everything down. Wash down all the doorknobs, all the light switches, the water fountain handle. You got to do that. But we're not doing it so we don't get sued. Okay.
Well,
we're doing it so we don't make people sick.
Yeah, that's true. The thing I also wanted to bring up, though, Ken, is the fact that a lot of times when people file litigation seeking damages, it's a scatter situation, a shotgun situation.
Shotgun.
You're trying to get the deepest pocket possible, and businesses might say, "Well, you can't prove it on us," but the legal costs of defending yourself, that could be a problem.
I agree, especially when you have like some of these meat producing facilities where you've got hundreds and hundreds of employees in the same organization getting it. Now, for them, it's going to be interesting because for those states that have workers' compensation laws, is that a comp claim? You contracted a virus, a disease at the workplace. So for them, it's going to be, I think, a lot easier to say it's likely that I got it at work. Therefore, I'm entitled to workers' compensation benefits. In a court of law, you could file a lawsuit, but causation is going to be very, very difficult to prove. But there will be people out there, no doubt.
If you got a question for attorney Ken Puzycki from the law office of Kenneth A. Puzycki, he'll be happy to answer it at 395-1450, 395-1450. Chapter 13, Chapter 11, Chapter 7, bankruptcy. I'm trying to remember off the top of my head the story we had this week about a notable firm that has filed for Chapter 11 bankruptcy protection. Go through the various chapters of bankruptcy if you can, Ken. Which one entails
I'm back in law school now, huh? Holy cow. No, I know enough to be dangerous, but I do know the difference between Chapter 7, Chapter 11, and Chapter 13.
Okay.
I do also know that there's a Chapter 12, but I'm not even going to pretend to know what it does. Chapter 13 is personal bankruptcy reorganization. Okay, so if you run into hard times, your debts exceed your assets, you can file Chapter 13. But that doesn't mean all your debts are wiped out. What it does mean is somebody's going to work with you to reorganize your debts, and you will pay them off. Maybe not all of them, but you will pay them off over time. Whereas a Chapter 7 wipes out all your debts. And you start with a clean slate. You don't have to pay anything back. You walk away and you start with a clean slate. Okay? In a similar fashion, when a business, you hear about JCPenney and what was the latest one?
That's the one I was trying to remember. I couldn't remember off the top of my head where one.
Yeah, it was a J. Crew, I think. J. Crew. A lot of these businesses were faltering, at the time, but prior to Corona, and after Corona, they're obviously going down even further. But businesses typically will file a Chapter 11 first, which allows them to see if they can reorganize their debts and pay off their creditors. And if they can emerge, like General Motors emerged from bankruptcy. Some companies emerge back from bankruptcy. They start out Chapter 11, they reorganize, they pay their debts, and then they emerge like a phoenix, right? Some companies shutter their doors and file a Chapter 7, walk away, never to be seen again. So a Chapter 7 wipes the slate clean, both for businesses and for individuals. A Chapter 11 is a reorganization of business debts, so the creditors are ultimately paid back. And Chapter 13 is a reorganization for individuals. Again, they don't walk away with the clean slate. They pay back their creditors. And again, from a societal standpoint, Chapter 11 and 13 are obviously better, but for a lot of companies and a lot of individuals, Chapter 7 is the quickest and leanest way to go. Just get her done and start from scratch. But from a following bankruptcy, if you file a Chapter 7, that's a Scarlet A. Okay, if you file for Chapter 7, you're basically saying, I had debts, I walked away from them, I'm starting from scratch, and it's going to be harder for that person to get credit, to get loans, and to get back on their feet. So a lot of people like to reorganize, show that they can get back on their feet, which will make it easier for them to get loans and to get credit after they've made it through the process.
And that's the point I was going to bring up about the Chapter 11 situation. There is a perception that a company or a outlet that files for Chapter 11, doesn't get that scarlet A, as you mentioned, Ken. But still, there is that perception, and not just from the consumer, but say from the supplier. Hey, wait a minute, we're going to supply that company, and they've already filed for Chapter 11 once. They might think twice about that. It's not a scarlet letter, but it's definitely putting up a red flag.
Yeah, and they may just demand cash up front. Whereas before they might give you, your inventory or your supplies on credit, they might tighten up that credit and say, we'll still deal with you, but we want cash up front. And that can be a hindrance to a business trying to get going again.
If you got a question for attorney Ken Puzycki, he'll answer it at 395-1450, 395-1450. Sorry to throw you the curveball on the
No.
bankruptcy.
I'm good with curveballs. Now, I'll segue you, though. I'll segue that into the probate administration, okay? What happens when somebody dies and they got a boatload of debt? How do those creditors get paid, okay? And if any of you have ever read the Sentinel and the classified ads, typically I know our ad comes out a lot of times on Thursday. If we're representing an estate of a person that has died, we have to file and publish what's called a notice to creditors. And if you die north of 32nd Street, we file it, we publish it in the Sentinel. If you live south of 32nd Street, you have to publish it in the Allegan County Register. But that puts the world on notice that, hey, Gary passed away. Before the kids get anything, you have to make sure the creditors get paid. And that notice in the paper puts the world on notice that you've died and gives them a 4-month period to file a claim against your estate. Okay? So before your kids get anything, the creditors have to be paid first. Similar to bankruptcy. Before we're going to let you, get back on your feet and open a new business, you're going to have to pay your creditors, whether it's a Chapter 11, a Chapter 13, a Chapter 7. It's a variation on theme, but creditors want to get paid, and we want businesses to loan money. We want banks to loan money. We want credit cards to loan money. We want businesses to sell things on credit to keep the economy going, and the way to do that is to give them some level of assurance that they're going to get paid before other people get paid. In the case of a probate estate, they're going to get paid before the kids get any money.
If you got a question for attorney Ken Puzycki, he'll take it at 395-1450, 395-1450. Let's return Ken to his law school days, shall we?
Oh.
I need you, because we have gotten a request, to please explain the term fiduciary responsibility.
All right. Well, in law school, I sat in the back row near the door, and there was a reason for that. But this one I can handle to a degree. So if you have a power of attorney that names me to be your agent, okay, as a lot of people do, that's one of the things we do. We have clients sign powers of attorney that allow their spouses or maybe their kids to take care of business for you if you're sick, okay? That relationship between you and your agent is a fiduciary relationship. If I'm acting as your agent under a power of attorney, I am a fiduciary for you, which basically means anything that I do, I'm not doing for Ken. I'm supposed to be doing it for Gary. And my allegiance, my fiduciary duty is to do what's in Gary's best interest, not mine. Okay? Now, that example expands to a lot of different relationships. An executor of a will. If I'm administrating your estate when you die, I am a fiduciary for that estate. I can't be cherry picking assets. I can't be buying things at a discount from the estate. Why? I'm breaching my fiduciary duty to the estate. Same thing with the trustee of a trust. If you are the trustee of somebody's trust, you have a fiduciary duty to follow the terms of the trust agreement, to not engage in conflicts of interest and self-dealing. That is another fiduciary relationship. And the last one that's obvious is a medical power of attorney. If you are a patient advocate for somebody, you have a fiduciary relationship with them to follow their instructions, to do what they wanted to do according to the terms of their medical power of attorney. But on a broader scale, a fiduciary relationship also applies to employer-employee. Okay, if you are an employee, you have a fiduciary. If let's say you're in the accounting department of a company and you're managing the books, you have a fiduciary relationship to manage those books and not to engage in self-dealing. So the broad term fiduciary relationship encompasses a lot of different relationships that we engage in every day, and we just don't realize it.
Yeah, the term fiduciary has been used by a investment concern that has put some ads in some of our network programming about why they don't charge as much because we have a fiduciary responsibility to our clients. Well, that's a little explanation what the word fiduciary really means.
Yeah, in fact, there was a rather large change in the law. It's probably been 5 or 6 years ago, where financial planners, the law made it very clear that they have a fiduciary relationship to their clients. The most important of which is the disclosure of how they get paid. Okay, because if I'm your financial planner and I sell you a bunch of mutual funds, okay, a lot of times those mutual funds will kick back what are called 12B1 fees. Okay, the mutual fund company pays me for managing that account. Okay, I have a fiduciary relationship and that relationship requires me to disclose how I'm being paid. Hey guys, I'm getting 0.65% from the mutual fund company for managing your funds. Now, does that motivate me to sell that mutual fund to that client? Maybe it does, maybe it doesn't. But a fiduciary is supposed to be doing what is in the client's best interest, not the financial planner's best interest, which is really what gives a lot of annuity salespeople a bad name. You know, a lot of people poo-poo annuities. Oh, annuities are a scam. Well, the reason they have that reputation is because in the past, a lot of annuity companies would pay 6, 7, 8% commissions when somebody sold a client an annuity. So if I sell you a $100,000 annuity, I get $8,000. Boy, that's a great deal for me. But what if you're 95 years old? Is that good for you? Probably not. Okay. So that's an example of breaching that fiduciary relationship or that fiduciary duty. I have a duty to do what's good for you, not what's good for me. And as an attorney, I have a fiduciary relationship to do what's best for my clients, not what's good for Ken. And there's gray lines all over the place in all these different relationships. But if you have to ask the question, am I breaching the duty? You're probably answering your own question. You know, your gut has to be able to tell you whether you think you're doing something a little off the chart. And if you are, you don't have to ask the question because you just answered it.
I need to bring this story up, and this goes in the category of why do we see warnings about caution, contents may be hot on the little containers, in the sense of, oh, here's another interesting lawsuit. This is out of Paris, France. Let me read you the story, Ken, and then I'll get your comments on this.
All right.
A French man is receiving a $45,000 severance package after he said his job was too boring. Frederick Desnard worked for a perfume company, Inter Parfums. and says he was demoted after losing a client, and that the new job responsibilities were so dull, it caused him enough stress to have an epileptic seizure. The workers' court ruled that Desnard had a bore out and received the large settlement. With all due respect for those who are suffering from epilepsy, and the circumstances may be legitimate, but still, I have my questions about that particular story as well.
Well, that smacks of a workers' comp claim. Okay, compare that to somebody who gets carpal tunnel from typing. Now, obviously, that person found a doctor who was able to create a nexus between his boredom and his epilepsy. Now, I'm not a doctor. I'm not going to pretend to be one. But obviously, that expert witness was able to convince a trier of fact. In France, that would have been a judge, not a jury, that there was a nexus between the job and the epilepsy. But it's interesting at best.
Now, Peg has something a little bit further because she's done some, and when I first mentioned the story a couple of days ago, she's done some digging on this.
So what happened was, this was a manager, and they did one of those deals where they took away pretty much all of his management duties and stuck him in a little cubbyhole room. So there's a certain level of distress. And I don't know exactly how French law works, but in a situation where somebody is not fired outright, they're trying to force them into quitting because firing them might be wrongful, but when they're trying to force someone to quit like that and they remove all their duties, and you probably know stories where basement office, cubbyhole, you got to work at another location. Is that something that's actionable?
Well, I think it's dangerous. Okay, so that is akin. Now, it's not a direct analogy, but that's akin to a landlord shutting off the water or shutting off the heat or shutting off the electricity to a tenant who may not be up to date on their bills. And by turning off the heat or turning off the water, that's what we call constructive eviction. If I had an employee, and that's really a good idea, I'm thinking about which one of my employees I'm going to do that to. But if I have an employee who's totally antisocial, and I really don't want to fire them, because if I fire them, what are they going to do? File unemployment. If they quit, they don't get to file unemployment. So I'm going to make their lives so freaking miserable that they're going to want to quit rather than be fired. A good attorney would say that was a constructive termination. You made my life so miserable, I had to quit. So I'm going to file unemployment benefits. And I'm going to get them because although I didn't voluntarily quit, you made my life so miserable that I had to quit. It was constructive termination. They probably don't have anything similar to that in France, but we do have that here in the States, and certainly in Michigan.
Attorney Ken Puzycki, we want to thank you very much for spending some time with us today on WHTC's Talk of the Town, for joining us in the Zoom conversation. And if all goes well, we'll talk to you again in the month of August, unless I'm fishing, in which case you get Andy Wood or Sharmila Rajani. That sounds good. Both of whom are fine attorneys. We look forward to that as well. On 99.7 and 1450 WHTC.